Yes, good afternoon once again to all the participants. We are in the final session, and that is the session 10 of our 1 week online faculty development program. So, the last topic of the last session is on IPR, patents, copyrights, trademarks, and innovation protection. So, it is my privilege to introduce our final speaker of this FDP, Advocate Kanchal Rasal, a renowned intellectual property rights expert associated with AM Legal Associates Pune. Advocate Rasal brings a rich professional experience in patents, copyrights, trademarks, and innovation protection. Her expertise bridges research, innovation, and legal frameworks. In this session, she will provide practical insights into patents, including types, documents, stages, and timelines, along with copyrights, trademarks, and strategies for innovation protection. Advocate Rasal, we are delighted to have you with us today. Ma'am, I request you to kindly take over the session. The virtual dice is yours.
Yes. Thank you, sir. Thank you for the introduction. And I am privileged to be here and share my insights on the topic of intellectual property, including patents, trademarks, and copyrights. So, I will share my screen and walk you through the basics of the intellectual property. And we shall also take any queries at the end of the session regarding patents or, in general, intellectual property. So is my screen visible?
Yes, ma'am.
Okay. Okay. So basically, when we talk about intellect, so all of us who are present here, we have been using our mind creatively in a lot of ways, and we are capable of rational thought, and we are able to uh, derive inference, or we are able to derive a kind of conclusion of whatever thought process we have, and we are able to discriminate, or we are able to uh, check what is towards a constructive being. So that is where we are applying our intellect or intellectual ability. So we use our mind very creatively, and whatever is the result of our thought process will create something which is different from what is already known. So, knowledge and our intellectual ability separates us from other human beings. So, basically, when we talk about any kind of intellect, we go to property. So, when we talk about property, property is something which we attribute to value or possession, which is already always in the form of a tangible asset. That is, we should be able to see it in the form of a practical being. And property also, we talk that it should be able to be transactable, it should be usable. So that is how we look at any kind of property. So when we look at the types of properties, there are mainly movable and immovable types of properties. So mostly whatever we own are valuables. We have gold, we have diamonds, we have our home, we have car, or we even have certain bonds. So all these things come under the types, various kinds of property that we own, or we claim ownership on that. And there is a very interesting part to this, that intellectual property. So whatever you develop from your intellect or from your thought process is something which we can say that it is attributed to intellectual property. So when we talk about IP or intellectual property, we can say that it has value, it can be assigned, it can be licensed, it can be transacted, and it can be used for society at large. So like any other kind of property you have, whether it is movable or immovable, Even intellectual property is able to be transacted in the same way. Only the difference is that it is creation from your intellect. So that is the only difference between the other form of property. Intellectual property also has value. We can assign it, we can license it, we can transfer the rights, we can do transactions. So it also has a value like any kind of other movable or immovable asset that you own, and you can have an ownership to this. Like you have a legal ownership to the property that you hold, even you can have an ownership to the intellectual property, and still it can be used for society at large. So that is an added advantage. Now, when we talk about intellectual property, whatever you create from your intellect or your creativity is called as the property. But until and unless you protect it, then it till that time it is only property, but once it is protected it becomes your right. So whatever is the creation of your intellect, once you protect it under whatever kind of right is applicable in the particular jurisdiction, it becomes right. So there are six types of intellectual property rights that we can say that we can safeguard in India. So it includes patents, trademarks, industrial designs, copyrights, geographical indications, and plant variety protection right. So whenever you are able to register your intellectual property, then only you can claim a right over that property. Then the IP becomes IPR, that is intellectual property right. So, how we can say that it is categorized? So, it is categorized based on the expression of the creativity. So, suppose it is an invention, then it belongs to the category of patents. When it is a literature or artistic work or it is music, it is protected under copyright. When there is a certain trade name or certain symbol which is marketed, and a specific company logo which attributes to that company, that we can safeguard under trademark. And articles, so articles is something that we can protect under design. So in design I'll elaborate that whatever is the aesthetic appearance of a particular device or a particular article, so we are not safeguarding its literature or the symbol or the technology behind it, but just the look of that particular article, then we register it under industrial design. So these are the basic types of intellectual properties that we will be facing. And in our day to day life, we can register hundreds of things under all of this. And then we can say that we can claim a right on our creativity. So, for example, now I am sharing various types of intellectual properties here. So, suppose we see this logo of Bajaj Allianz. So, this is a trademark. Here we have a trade name and it is also a logo. So, this is a trademark. Fleet Guard, if we see here, this is a trademark. If we see this drone flying, this is something that is protected by patents, because whatever technology is there inbuilt in this particular system, it will be safeguarded by a patent. Now we see this particular wheelchair. Now if there is a specific locking mechanism in this wheelchair which has not been disclosed earlier, we can say it is protected by patent. But the another intellectual property which is important here is design. So the look of this particular chair and the its appearance is something that is protected by industrial design. Now if we see this particular car, some parts of this car can be protected by industrial design if there is a specific mechanism of working wherein there is a low cost fuel technology or some other fuel technology used that can be patented. Now here we see this is Shiv Mudra of Raja Shiv Chhatrapati. So of our Shivaji Maharaj. So Shiv Mudra is something that today it cannot be copyrighted. But at that time, if copyrights were present, we could have copyrighted the Shiv Mudra. Then this is a particular photograph. So when we see that a photograph, it is a copyright, and that intellectual property belongs to the person who has photographed this particular image. Or if a person has employed that person to take a photograph, then this intellectual property belongs to the owner who has employed that particular photographer. Then here we see a particular painting. So this is again a subject matter of copyright, wherein we can say that the person whoever has painted this owns the copyright to this particular intellectual property. Now we can see here is a millet bar. So there are multiple intellectual properties again here. It is safeguarded by a trademark for the trade name. Then for the design of this particular wrapper, so whatever is the aesthetic appearance of this wrapper, we safeguard it by industrial design. So I am just trying to give you a basic overview of the different types of intellectual properties. Now, moving on to the most important intellectual property, that is patent. So, when we talk about patents, patent is a right which is granted in respect of an invention. And invention can be only of two categories, either a product or a process, or both product or process. So, whenever we are envisaging any kind of creativity which is going to contribute to a technological process, we have to check whether it falls in the category of product or process or both. Then only we can say that it is an invention which is patentable, and it should also satisfy the conditions of patentability. So there are certain conditions which are universal, which are similar throughout the world, and there are certain conditions which we can say that are given in the sections of the Indian Patent Act, which shows what is not patentable in India. So we have to check for all those conditions, and then once we can say that these all things are satisfied, we can move ahead for a patent. So basically, what are these conditions of patentability that we'll see? First, we'll see what are the rights of a patentee. So whenever we say that it is a right that is granted in respect of an invention, it is an exclusive right. Exclusive right means you exclude others. Nobody else other than you can use that right. So exclusive right, and it is for a period of 20 years. So from the date you file your patent application, you get a right of 20 years to exclude others. Exclude others from what? Making use of your invention, producing your invention, importing your invention, and selling your invention. So basically, you exclude others from exercising the right over your patent for a period of 20 years. So this is something that a patent grants you. Now, moving on to what is patentable and what is not patentable in India. So, basically, when we look at the Indian scenario, it is very important as per Section 3 of the Indian Patents Act, certain things are not patentable. So, if we look at the broader aspects, abstract ideas or theories are not patentable. So, suppose we say that I have prepared a perpetual motion machine, and there is no technical proof to it. It is just an abstract theory that yes, there is a perpetual motion machine, so that is not patentable. Then anything that is against moral or obligatory rights, that is not patentable. Traditional knowledge is not patentable in India. Any kind of method of treatment is not patentable in India. Then computer program as such, per se, or algorithm is not patentable in India. So these are certain criteria that has been laid down by the government of India, that is not patentable in our country. So, what is actually patentable? We should be able to show that any kind of a technical solution to a practical problem, if we are able to show there is a technological improvement or advancement or a solution to a practical problem, that is something that is patentable. And again, as I mentioned, two criteria: product or process, or both product and process. So what is patentable? A new product or system. So product is a very broad term. In this, we can say it can be a system, it can be a device. So any kind of system device falls in the category of product. So new product or system is patentable. New process of creating new product or system is patentable. And new process of creating existing product. If we are able to show that my process is new, it is innovative, and it is cost effective, or it is technologically advanced than the known processes, even if the product is known, it is still patentable. So the patent office gives patent for only these kind of innovations. So, moving on to the most important thing, that is, what are the conditions of patentability? So, these three conditions are universal. If we file patent in any country in the world, they will check the invention based on these three conditions only. So, these are novelty, inventive step or non-obviousness, and utility. So, the patent office always assesses these conditions, and if these three conditions are satisfied simultaneously, then only they take it ahead for patent application. So, the most important is novelty. So, when we talk about novelty, it is that any kind on the date of filing, your application should be new. That is, it should not be known in the public domain before that date of filing. So either you should not have published it, or there should not be any kind of disclosure in any seminar or conference, or it should not be there in the form of any kind of YouTube video or on Google. So it should not be there in the public domain. That is, on the date of filing, it should be new. Next is inventive step or non-obviousness. So this is a very tricky criteria. Here we have to show that our invention has technical advancement over prior art. So what does this mean is that there are many people who are working in the same domain in which you are working. So prior art is something that specifies whatever research is being done in that particular field. So your invention should have some kind of technical advancement over whatever is known in the prior art. And the third is utility. That is, useless inventions are not patentable. There should be at least one practical application that we should be able to prove. Then only we can say that that is patentable. So these three conditions are the most important. Now we move to the types of patent applications. So these are basically an overview of the types of patent applications. So ordinary application is the application wherein you file an application for whatever product or process you have, and you file it with the patent office. Then provisional. Provisional is when your invention is not at a completely developed stage, but there are many criteria because of which you want to secure your patent application. So this is when first thing is you have a fear of disclosure. You feel that somebody else is also working on the same technology and I want to file. So whenever you apply for a patent, first to file is the person who will get the priority date. So when whatever disclosure you have, whatever concept you have, even if it is not at a completely developed stage, still you are in the development stage, but you want to secure a priority date, or you have a seminar or a conference and still you feel that it will get disclosed in the public domain, before that I want to secure a priority date, that is when you file a provisional application. So it gives you a priority date with the patent office. Complete is something wherein you file the final application, which is a non-provisional application. So when you have all the technical details complete, you have all the experimental data with you, and you feel that yes, all my studies are completed. When all the technical details along with the claims you can file, that is a complete application. Then the next one is PCT, that is Patent Cooperation Treaty. So when you want to safeguard your invention in countries outside India, at that time we have an option of PCT application, which we call as the international rule, which gives you a channel to file the patent application in multiple countries. So I will discuss in detail about PCT also later, but it is a unified channel which helps you get the priority date of India and you enter into various countries outside India. Now, conventional application. Conventional is when you want to select only a single country. PCT is where you want to select multiple countries. But conventional is you want to select only one country and you can file a corresponding application to the patent in India in that particular country. Then we file a conventional application. Then the next is patent of addition. So patent of addition is when you have already filed a patent, for example, for a technology X, and in course of 2 or 3 years you have made some improvements in the same technology, and uh, when you have some serious advancement in that particular technology, so in that case if you file a separate patent application, what happens is your first application will be cited as a prior art. So it is best that if it is an addition to your own technology, you file a patent of addition, the advantage being that your own patent is not cited against your application and you get the priority date of the first application. So suppose you file your first application in 2025 and the patent of addition is filed after 3 years, it will get the same term as the original patent and the same priority date of the original patent, and you get two separate patents granted in your name. Then next is divisional application. So divisional application is something which can be either directed by the patent office if they feel that there is no unity of invention. That is, they feel that there are two inventions in your application. So when you file, you might think that no, this is a single concept. This does not mean that a product and process can be separated out. Both the product and process is a single inventive concept. But suppose there is a second inventive concept, and you while filing you did not understand, the patent office might direct you to separate out that application, or an inventor on his own, if he wants to separate out an application, he can file a divisional application based on his ordinary application. So these are the various types of patent applications. Now, moving on to the various patent search tools. So when we say that we want to file a patent application, we basically first do a prior art search, or we do a state of the art search. So what does this indicate is that we assess what is the state of the art in a particular domain, and for that there are various tools. So there are some open source tools and there are certain paid databases also. So basically INPAS is the Indian patent search system. Then WIPO, World Intellectual Property Organization, has an interface called as Patent Scope. Then European Patent Office has an interface called as eSpaceNet. Then Google Patents is an open source interface. United States of America has USPTO. Japan's JPO, that is Japanese Patent Office, has JPAT. Then SIPO is China, SIPO, and KIPO is Korean Intellectual Property Office, for which their interface is KIPRES. So what does these particular search interfaces provide is they provide a fielded search. They provide you various fields like abstract claims, complete specification, applicant, title, and you can search specific keywords in those fields. So combination of keywords or combination of a fielded search will give you a set of records from which you can assess whether what is the state of the art. But most of all these patent scope or these, they do not give a very refined search. They will give you an overview. So for a very refined search, mostly paid databases are used. There are a lot of paid databases that provide a very refined search. So there are some tools called as Thomson Innovation, then there is Questel Orbit, there is PatSare, PatBase. There are a lot of other tools also. So these are some of the leading tools which give you a paid system for refined search, because even if you miss out a single patent, that might be something which is a very big prior art for your application. So finding out the prior art is very necessary, and most of the tools are very hands on. It is very easy to use these interfaces. It is always good that you go and search these interfaces to try to see, just like you search research articles, in the same way you need to search the patents. You need to search what is the state of the art and where my invention lies, how different it is from the prior art. So that is something these tools help to assess. Now, moving on to the actual life cycle of the patent application. So, in this, we first is the concept stage of the invention, then filing of the application, examination of the application, hearing and grant stage, and the post grant stage. So, all these things go into the life cycle of the patent. Now, the first is when we say that the invention is conceptualized. So, at this stage, what a patent attorney does, or whoever is going to file a patent, first he assesses what is the stage of my invention, whether it is at a concept stage, whether it is at a random developed stage, it is at a completely developed stage, whether it is at a prototype stage, pre-launch stage, or already launched. Sometimes the product is already in the market and then you go for patenting. So it has happened like this. So you first see what is the stage of the invention, then you first check what is the stage of the prior art search, where does my invention lie in the state of the art. Then what is the stage of the prototype? If there is any prototype involved, what is the stage of pilot study? So all these studies goes first into the invention conceptualization and assessment. So this is basically what we attorneys do when we first get an invention, is we assess the invention, where the invention lies. And once we get to know, after the prior art search, after the invention assessment, whether there is some kind of patentability in this, whether there is some kind of novelty, inventive step, or industrial applicability to this, then we proceed to the next step. So before we move to the main step, that is filing of the patent application, as I already mentioned that provisional application is an optional stage. So if you are in a hurry, that your invention is not yet completely developed, but you want to get a priority date, you want to establish a priority date with the patent office, you file a provisional application with the Patent Office of India. So the advantage being that you get 12 months to file the complete application. So in that 12 months, you can refine your application. You get the patent pending status already. If you have any third party, you can disclose it. If you have any seminar or conference, you can disclose it. And in that 12 months, you can develop your invention and file the complete application. Your priority date is preserved. So this is an optional stage that is provided by the patent office, but it is very advantageous. And when it comes to commercial applications, so if you have any third party investors, so suppose you have developed some invention, but you do not have the technical know-how, or you do not have the setup, but you have some third party who is ready to invest in it, at that time also it is very advantageous to file a provisional, then file an NDA with the third party, you disclose it, you use their technological setup for developing your invention, then file a complete specification. So the advantage being that your priority is preserved, you get third party input, and you get to develop your invention also. So that is another advantage of provisional application. Then we move to the second stage, that is filing of the patent application. So basically, first, once the evaluation of the invention is done, we draft the application and we file it with the patent office. So patent application is filed under section 7 of the Indian Patents Act. And once the complete specification is filed, it is published in the Journal of the Patent Office of India. So until and unless it is published, it is not in the public domain. So only who has applied the patent and the patent office knows that you have applied for so and so patent on so and so date. It is published after a specific timeline, that is 18 months from the date of filing, in the Journal of the Patent Office of India under section 11A. And at that time only it comes in the public domain at large. So before that, it is not in the public domain. And at this stage, there is another entry, which is an optional stage, which I already mentioned is PCT entry. That is, if you are interested in safeguarding the same invention in countries outside India, you have to file a patent cooperation treaty application at the stage of complete specification, that is 12 months from the date of filing of the application, which allows you to save the priority of India in whichever country you later enter. So this is a crucial stage in when we file the application. And at this stage also there is another option of request for examination. So the patent office, they will not take your application for examination unless you request an examination under section 11B. So once you request them, then only they examine your application. So all these steps go into the second phase, that is filing of the patent application. Now we move to the third phase, that is examination. So once we request the patent office that please examine my application, then they take up for examination and they issue a first exam report, that is FER. And this is issued under section 12 and 3. So, what is an FER? It is a list of objections based on novelty, inventive step, industrial applicability, and the conditions of patentability. So, whatever the patent office has any kind of objection on your application, they give it in writing, and we have to respond to this FER in 6 months. So, the timeline is 6 months under Section 12, Rule 24B. So it is called as putting the application in order for grant. So once we respond to the FER, we say that the application is in order of grant. And this particular timeline of 6 months can be further extended by another 3 months under section 21 and rule 24B. So if you need more time or if you need more technological uh, studies to be done to respond to this FER, you can extend it by another 3 months. So total in 9 months, we have to respond to the first exam report of the patent office. And at this stage of examination, the patent office, if it is convinced that whatever response you have given to the FER, it is something which is satisfying whatever objections they have raised, 20 or 30% of the cases, the patent is granted at this stage itself. That is FER response. But most of the times the patent office, they have some outstanding objections which are not satisfied at the stage of response to FER. And at that stage we move to the fourth phase, that is hearing and grant. So whatever outstanding objections are there, they issue a hearing notice under section 14. So whatever objections are pending, we have to appear before the patent office in a hearing. So this is the Controller General of Patents who is appointed by the patent office, who examines our application, and we have to appear before him. So we can have online or offline hearings. Mostly all the hearings are online now. So a specific date and time slot is given, and we have to appear and defend whatever objections are raised. And after that, we have to also submit it in written in the form of post hearing submissions. So after the stage of hearing, again the patent office goes for grant or rejection of the patent under section 43(1). So once we say that the patent is granted at the stage of hearing, it is again published in the Journal of the Patent Office under section 43(2). So earlier was only the publication of the patent application, and now it is publication of grant. So here we can say that the hearing stage and the grant stage comes to an end. So after this, whatever is there is called as post grant proceedings. So as I earlier mentioned, that patent is granted for a total period of 20 years. So this particular stage is over in either 1.5 or 2 years based on the issuance of FER and hearing. So there is no fixed timeline. Complete specification you have to file in 1 year from the date of filing of provisional. But after that, when an FER is issued and when a hearing notice is issued, is at the discretion of the patent office. So sometimes it is issued in 6 months, sometimes it is issued in 1 year. So based on the timeline, generally the grant takes 2.5 years, and all the proceedings that happen after the grant are the post grant proceedings. So the remaining term of 20 years of your patent, what all things happen in that? So first and the most important thing is maintenance of the patent. So whatever patent is granted, you have to renew it with the patent office. So you have to pay a renewal fee with the patent office every year. And the renewal fee is something that the patent office has also provided an advantage, that if you renew for 2 or 4 years together, there is some discount. So that is renewal. Then second is statement of working. So when your invention is worked or not worked. So if it is worked, what is the revenue that is generated from your invention? That you have to submit to the patent office every 4 years. So after every 4 years, you have to give the patent a statement of working, whether your invention is worked or it is not worked. Then there is most importantly in the post grant proceedings, post grant opposition. So suppose there is any third party who is aggrieved by your invention, and they come to know that this particular invention is going to cause some kind of trouble in their market, they might file an opposition to your patent based on the grounds which are cited in the journal in the patent law. So no, not like this that anybody can oppose your patent. There are certain grounds. So suppose there is a third party who is aggrieved, or if they feel that their market might be affected or challenged by your patent, they can file a post grant opposition. So the period for post grant opposition is 1 year. So within 1 year from the grant of your patent, if anybody files a post grant opposition, you have to again go for the proceedings for post grant opposition, because these are mandatory proceedings by the patent office. Then another most important thing is licensing. So when we say that the patent is granted, you can license your patent to third parties and you can derive the royalty from working of your invention. Then another most important is vigilance and enforcement. So by vigilance and enforcement, we mean that if you come to know that there is a third party who is infringing your patent. So how do you come to know? Either you are working in a same market, or you are working in a same field and you come to know that there is some kind of a tender who is passed, which is passed by some other party. Or another thing is you always do a triad search. So you always try to search the latest patents on the patent impasse site, whenever they are published, every 3 months you take a list, and if you feel that somebody is trying to infringe your patent, or somebody has filed a patent after you on the same technology, you can go for an infringement suit, or you can ask that person to stop producing that particular product or that particular process. So if you have a priority date, you can enforce your particular exclusive right by being vigilant. So in vigilance and enforcement, it comes opposition is there, infringement notice or infringement suits we can file. And once we file an infringement suit, we are able to prove infringement to the patent office, we can also claim damages. So all these things go into the post grant proceedings. So basically, this is the entire life cycle of the patent. So it includes invention, then filing, examination, hearing, grant, and all the post grant proceedings. Uh, After this, we will look at what are actually a parts of the patent specification. So when we say that we are filing a patent application, so there are certain criteria when we file a patent application in India. So these are the main criteria where these are the main parts of the specification, which includes a title, field of the invention, background, summary, description of the drawings, detailed description, examples, claims, abstract, and drawings. So basically, when we say that a specification, so what is a specification? It is a technical document which provides a detailed outline of what is the actual technology involved in that particular invention. So the description is such that it actually elaborates what is the novelty, what is the inventive step in particular technology that you have that you want to safeguard. So, our when we write a patent specification, there are certain parts which are very
I think there is some technical problem. The expert will join soon.
hello.
Yes, yes, ma'am. Yes,
Yeah, I'll share screen.
yes, yes, yes. Please go on.
Yeah, is the slide visible?
Yes, ma'am. Yes.
Yeah. So when we talk about what are the parts of a patent specification, so the most importantly is when we say that the particular description should be enabling. Enabling means the most important criteria of a patent specification is enablement. That is, your specification should describe all the technical details that you want to safeguard, and all those specific technological pointers should be included in your specification. It is also called as sufficiency of disclosure. That is, if you say that I want a patent on this and this, but I don't want to disclose all my technology, then the patent office will not grant your patent. You should be able to give all the technical details in your specification, which is also called as enablement or sufficiency of disclosure. Until and unless you give or you write down all the specification, all the technical specifications, it is called as non-enabling disclosure. That is, you are saying that I want to claim so and so, but you are not giving any kind of technical details of that particular thing in your specification, then that claim will not stand. So we can say that description is something which should give all the technical details, and claims are something which define the boundaries or the legal boundaries of that particular invention. So when we say that claims define the legal boundaries or the scope, is that when you enter a market, that particular claim should be able to stand for a period of 20 years, and you should be able to exercise that right on that product or process for a period of 20 years, an exclusive and a monopoly right. So when will that happen? When your claim is strong. And when your claim will be strong, when the detailed description is enabling. So even though claims describe the legal boundaries of the patent, your detailed description should be enabling and it should be sufficient. So there is a technique of writing all these things. Claims are written in such a way that you claim a particular system, or you claim what is the product, but whatever are the technical details of the product that goes uh, that are there, the working, the mechanism, that all goes into the detailed description. Another most important thing is examples. So suppose we are looking at a product or a process. So most importantly, we should be able to exemplify our particular specification with at least one or two working example. Working in the sense, we should be able to show the actual mechanism, that if I put so and so things together at so and so processing temperature, so and so processing parameters, at that stage, at stage 1 I get this, at stage 2 I get this, or this is my final product. So that is an exemplary details. So by this, what happens is, if the patent office, they do not understand your invention from the detailed description, at least by reading your example they should be able to process that this is how my example, or this is how my product will actually work when I work it in the laboratory, or when I work it in a large scale manufacturing process. So at least one example we should be able to give. So this is again a part of clever drafting, like what kind of example you give. But still, examples always, we can say that, define the sufficiency of disclosure, and exemplary details are always something which support the specification when we go at the stage of FER or hearing. Now, another most important thing is drawings. So there are certain rules which have been laid down by the patent office, and it is mentioned in the patents act and patents rule, that there is a particular line spacing that we need to use. Then all these drawings, these should be specifically grayscale or black and white. It is better if we give line drawings, because line drawings are something which we can give various views, perspective views, cross sectional views, 3D views. So all these we can provide in the form of line drawings. So, and the another most important thing is description of this drawing is also important. So when we refer to description, in our detailed description we should be able to correlate that drawing. So all these things is a part of better writing skills. So how much data, what kind of technical data, and how refined data we provide in the specification is how strong the patent is. So these are all parts of clever drafting skills, that we can say that you need to disclose your invention enough for a patent to be granted. But if you have not disclosed this enough, there is an objection called as insufficiency of disclosure, which the patent office raises. So it is always good that we disclose it enough that a person skilled in the art will be able to work your invention. So this is what goes into the patent specification. Now, the most important thing is how we file it. So there are certain forms, there are a lot of forms, but the most important forms are here, and the timelines. So timeline of patent, as I already mentioned, is it is 2.5 year a patent is granted. 1 year we take for filing a complete specification. Again, FER, if it is issued in 7 to 8 months, we can respond that immediately in 1 or 2 months. Again, 7 to 8 months for hearing. But there is an again an option, if you want to expedite your application, that is, if you want to fast track your application, there is a separate form 18A, which you can file with additional fees, and you can fast track your application, but still it takes 1 to 1.5 year for the entire proceedings to be completed. It is again dependent on how fast do we respond to all prosecutions. So the timeline is set by the patent office, but also we have to respond very quickly so that we get over with the prosecution first. So I will first discuss the forms. So form 1 is the application of patent. So whatever details you fill in this is, you have the applicant name, you have the inventor name. Now applicant is the person who owns the invention. So whoever you want as an applicant will be the owner of that patent. So applicant can be an individual, startup, small entity, educational institute, or large entity. So these are the entity types of an applicant. So if there are two applicants, 50% ownership to both of them. If there are four, 25%. There can be any number of applicants. The second criteria is inventor. So inventor is a person who has an inventive contribution to the invention, but he is not the owner of the invention. So this is the other criteria. So you can mention the name of an inventor for the people who have an inventive contribution to that invention. So in this form, there are other details like the title of the invention, address of the applicant, and whatever forms you are filing along with form 1. So with form 1, we have to always file form 2. Form 2 is the actual draft of the specification. So actual draft means either it is the provisional or the complete specification with all the details that I had already mentioned in this. These all details are there. So this is a specification which has all these details. So this goes in form 2. Then form 3. Form 3 is statement and undertaking under section 8. So whatever application you file outside India, you have to give details of those to the Indian Patent Office. So that you have to give in section in form 3. So you have to file all these forms along with the patent application. So it is 1, 2, 3, and 5. These four forms you always file together. So one is the application of the patent, two is the draft, that is specification, three is statement and undertaking, that is any kind of foreign application you have to give the details. Five is declaration of inventorship. So whoever are the inventors, they they have to sign this particular form and they have to declare the inventorship. Then form 9 is request for publication. Request for publication is if normally when you file a patent application in 18 months it gets published in the journal of the patent office. But if you want it to be published early, then it is a request for early publication that you file in form 9. Then form 18 is request for examination. You have to request the patent office to examine your application until and unless they do not take it up for examination. Then you have 18A, as I mentioned, for expedited examination. So if you want to fast track, you can file 18A. But again, there is a criteria for 18A. 18A can be filed only when at least one of the applicant is a female applicant, or the applicant is a startup or small entity, or the applicant has applied for PCT and India is considered as an international searching authority in PCT. So there are certain criteria which we should be able to satisfy, then only we can file form 18A. Then there are some other forms also which are not that important, but when you go to the stage of FER or hearing, you will require form 13. Form 13 is amendment to the specification. So whenever at the stage of hearing or FER, the patent office asks you to amend some claims, you have to amend it and file form 13. So whatever amendments or changes you make can only be made to the claims. you cannot make any change to the specification once the complete specification is filed. Only the claims can be changed, and that too at the discretion of the controller of the patent. So, Form 13 is filed for any kind of amendment. Form 26 is authorization of patent agent. So suppose you are not going to file it on your own and you are going to file it through a patent agent, patent attorney. This Form 26 allows you to file authorization of the patent agent. Then there is another Form 28. So if you are registered as small entity or startup, you have to file Form 28 to get that status, because small entity or startup gives you a concession in the government fees. So if you file Form 28 along with the startup registration certificate or the MSME certificate, then only you get that concession. Then Form 27, as I mentioned, statement of working you have to file with the patent office every 4 years. So that is Form 27. And 7 and 7A is opposition. So this is something is not important at this stage. So if somebody files an opposition to you, it is 7. And if it is a pre-grant opposition, if it is filed in Form 7A. So these are the most important forms. And now the PCT timeline. So this particular figure here, this is the Patent Cooperation Treaty timeline, and this is one of the most crucial entries for safeguarding your invention in countries outside India. So, what is the advantage of this is that India is a signatory to Patent Cooperation Treaty, and there are 158 countries other than India who are signatory to PCT. So, PCT gives us mutual rights in these 158 countries. And another advantage being that if you file an application in India, in 12 months you file the PCT application, you get rights as good as you have filed in 158 countries. So once you file the PCT application, you get, it is just same as claiming the priority in all the 158 countries, provided you select those countries in 30 months. So it is just like you get an extended timeline in that 158 countries, and provided you file those national fees in 30 months. So the advantage being that you don't have to file separate application in any country of your interest. The Indian application that you file, in 12 months you file PCT, and then you select the countries of interest. There you directly go for examination. So it cuts the cost by at least 5 times when you file the application in separate countries. And another advantage is that this 30 months timeline gives you enough time for research and assessment of what is your market country. So by the time Indian prosecution also gets over, and you get a good hold of where my market will be. So as far as our experience is concerned, maximum countries that are entered are 8 or 9. So big companies, they go into 8 or 9 countries at the most. So mostly 2 or 3 countries are only selected at this national phase entry, and the most selected countries are USA, then European Union, China, Japan, Australia. Then there is a treaty of African countries which we called as ARIPO. So all the African countries we can select. Then there is a treaty of all the UAE countries. So there is separate treaty of Southeast Asian countries. So we can select all these countries and we can enter them in 30 months. So the timeline for PCT is that you file the Indian application. In 12 months you file PCT. In 16th month, an ISR is issued. So ISR is International Search Report, which is same as that of FER, that is First Exam Report of India. So this ISR, it gives an opinion of the International Search Authority, just like that of FER. So it gives an objection on novelty and inventive step. And The only advantage is that it is an optional stage. We don't have to respond to that mandatorily. It just gives us an overview of where our invention lies based on novelty and inventive step. Then the patent application, that is the PCT, is published in the on the WIPO, World Intellectual Property Organization website in 18 months. Then, just like the ISR, there is an optional supplementary search that we can take, but it is optional. And at the 30 months or 31 months maximum, we have to enter the national phases, that is countries of interest. So suppose if at this 30 months we choose USA, China, Japan, in those countries the prosecution will go ahead from the stage of examination. You don't have to file, you don't have to publish, you don't have to request for examination. From the stage of examination, in those countries it goes. So every country has a separate route of prosecution. So USA, there is a supplementary search, there is a there are hearings also. In European Union there is two searches and hearings, so there are different timelines in every country. But after the national phase, it is more or less like Indian prosecution, and the patent gets granted in those countries. But this particular first timeline, we can have a unified system. We don't have to apply separately in all those countries. So this is the advantage of patent cooperation treaty, and it gives us advantage in entry in 158 countries who are signatory to this PCT. Now, moving on to more one of the most important thing is confidentiality of inventions and disclosures. So whenever you are going to disclose your invention to any third party, it is always better that you sign an NDA with them. Or whatever meetings you do, make sure you make an online meeting or you record those meetings. All the communication should be on email. So this helps you to have a clear and transparent handling, and you always in case of any kind of infringement, you always have a proof that when NDA was signed or when that meeting was conducted, how it was disclosed. It helps you for the licensing strategies also. So this is basically regarding the patents. Now, moving to copyrights. So, copyrights is something which is a creative expression in tangible form. It can be either literary work, artistic work, musical work, cinematographical work, or dramatic work. So, it can be books, research articles, or a software code in the form of literary work. It can be drawings, photographs, architectural design in artistic work. It can be composition and lyrics in musical work, cinematographical works, sound recordings, and scripts and choreography come under dramatic work. So, whatever are the computer programs or algorithms, AI models, is treated as literary work under Indian law. And any kind of training material, if you make copies of that, that can be that we can say that it can be protected under copyright. It does not protect ideas, concepts, methods, algorithms, or fact. So computer programs, when we say that if there is a logical systematic program that is written, only a copyright of that can be say. Copyright is something which gives you right of making multiple copies of it. So multiple copies of book, multiple copies of drawings, sound recordings, cinematographic works. So it can be only a right for making multiple copies. So suppose there is any kind of code also, it is only the copies of the code that you can copyright. Now, the duration of protection is for literary, artistic, music, and dramatic work. Whoever is the author, his entire lifespan plus 60 years. So, if we say that whatever copyright are Honorable Lata Mangeshkar has. So 60 years after her life also it will be protected under copyright. Then cinematographic film and sound recording 60 years from publication. Broadcast 25 years. So basically what are the rights that are granted to the copyright holder is reproducing or copying, distributions or sale, public performance or communication, adaptation and translation, creation of derivative work, and publishing and online display. And another uh, right to claim authorship and right to protect the integrity and prevent the distortion of work is also the moral right which is given under copyright. So some common misconceptions are that all online content, that is text, image, music, video, software, is automatically protected the moment it is created. So even if it is on Google or internet, it is not free to use, it is copyrighted. Or if I change or remix the content, I own it. No, altering or paraphrasing infringes the underlying expression. So it is mostly that it is not caught. That is why there is something that people are free. But if somebody is able to prove that there is copyright infringement, then it is taken under law. Then citing the source is enough to avoid copyright infringement? No, you have to take proper permission. Then if there is no copyright symbol or watermark, I can still use it, it is not copyrighted? No, copyright exists automatically the moment that particular artistic or literary work is created. So no symbol is always registered. Then I paid for the content, I can use however I want? No, you have paid only to grant access, not ownership to that particular copyrighted material. So these are some of the common misconceptions of copyright. Now moving on to trademark. So trademark is something that is very interesting. It is a unique sign or symbol, and it is used to identify the source of goods and services. So it is something which also represents brand identity and customer recognition. So it is something which is distinctive feature of your particular brand identity. So there are various categories: word marks, logos, taglines, sounds, colors, combinations, numerals, domain names, and hologram marks. So word mark are, suppose all these big names, Tata, Amul, Reliance, are brand names. Logos are the Nike swoosh we have, the Airtel wave we have. Then the taglines are there, Incredible India. Then various sounds or jingles that we say. So the Airtel tune, it is trademarked. Then we have the color combinations. Very specifically, we have to protect under trademark. So Vodafone's red or Cadbury's purple color. Then the numerals. So there are certain companies whose trade names only have numerals. So that is there. Domain names are there. Hologram marks or motion marks are there, which have animated logo transitions. So all these come under trademark. So basically, trademark, it protects brand identity. It prevents other from copying that mark. It builds consumer trust. It is a legally enforceable right against infringement, and it becomes a business asset which can be further licensed. The validity of trademark is 10 years from the date of registration, and it is renewal every 10 years indefinitely. So after every 10 years you can renew it. So, why do we register trademark? It gives an exclusive ownership, legal protection. It helps to build your brand value, which is very important when you expand internationally also. And it is essential again if you want to give for licensing or franchising. So that is where trademark is important. Then there is a basic step of registration of trademark also. So first we have to identify where the particular uh, trade name or my word, logo, tagline, which class does it fall. So first I have to check the class of goods and service. Then I have to conduct a trademark search to check if there is a existing trademark. Then I have to file the application with all the applicant details, description of the goods and service, digital representation of whatever logo, the class number, and the user claim. So where you want to use it, or if it is already an established trade name, when since when it is used, along with the proof. Then the patent office, the trademark office, they checks if the application is complete, and if it is complete, then they request an examination. So once a request for examination is generated, the examiner, he reviews the mark based on distinctiveness, checks the conflict with existing marks, checks with prohibited marks, and then issues an exam report. In that exam report also, if there is no objection, it is published. If there is an objection, we have to respond to that in 30 days. Once it is published in the Journal of the Trademark Office, then it is open for opposition period for 4 months. If no opposition, it is registered. If there is opposition, we have to again go into the prosecution and we have to face that opposition. Once it is registered, then you get a registration certificate. So certificate that is issued is with this particular R symbol, and it is for a validity of 10 years. So after this registration of trademark, you can monitor for infringement. So once you get a registration certificate, you can use this R symbol. And once you have applied for the trademark, there you can use that TM symbol. So this is basically regarding trademarks. Now I will talk about general licensing strategies. So basically when we say about licensing, it is you offer the exclusive right that you have to another person who is another entity who is a licensing to use product or sell the patented technology under agreed conditions. So this will help you to monetize your IP. Suppose you don't have the infrastructure, that person can work that invention. You can expand the market presence and reduce financial burden. So suppose you are working your invention in India and you have filed PCT and you have entered US UK. So you can license your technology in US UK and manufacture yourself in India. So these there are again types of licensing. Exclusive license is that you give it to a single party in whichever countries you are, or non-exclusive, you have multiple licenses which have geographical or territorial rights and which will be providing you royalty in terms of whatever licensing deed is being produced between the two parties. In that timeline you can have again, you can have licenses for a period of limited term. So after some term you can again renew your licenses. So these are all the things which come into the strategies that go into general IP and mostly for patenting. Then technology transfer. So again it is handing over of the technological know-how for exploiting the invention commercially. So here also when we say that when we enter into a licensing agreement or when we have some third party investors, so what it includes is we transfer our technology in the form of drawings, whatever SOPs are there, whatever manufacturing specifications are there, we give these details to them. Then there is a prototype, pilot batch, demonstration, training of the operation, batch processes, and validation and scale up. So all these things come into the technology transfer. So either this is done at your end or you do it through any kind of incubation centers, or it can also be directly transferred to the third party and the third party takes care of this. So there are various stages of technology transfers. It depends upon how large your patent is, what value does that particular IP have. Based on that, the technology transfer differs from patent to patent. Now, when we talk about commercialization, as I told already, so it all depends upon patent to patent. um, there are some stages where we have to go for a prototype validation, testing and performance benchmarking, scale up and manufacturing design. So we do pilot studies, line trials. Then we have to sometimes develop the supply chain system also. Then there is so in some cases you have to look for the regulatory compliance, then the distribution partnerships you have to take. So it includes launch, feedback, optimization, and expansion. So there are various strategies of commercialization. It depends upon what kind of product is there in the market, what kind of process is there, whether you are licensing the entire patent or only a part of that patent. So all these strategies depend upon the patent that you have, the valuation that it creates, the third parties that are involved, and what kind of revenue will be generated from that patent. So all these things vary depending upon the patent. Now, when we look at the startup and incubation system, so startup is something which even the government of India has provided a lot of boost to, and it is again commercialization of new product, technology, or business model of an early development company. So it is a innovation driven early stage company, and it is into uh, innovation. So when these particular companies, they are scaling up their businesses, these incubation centers, they help a lot with the development of these particular startups. So India is already one of the largest startup ecosystem, and these incubation centers, these provide the required infrastructure or the required mentorship or the required IP support that is there, that the startup on their own they do not have. So it helps in the commercialization and licensing and market entry of these particular startups. So there are a lot of incubation centers in India, and there are a lot of incubator models also. So there are academic incubators, there are government incubators, there are corporates who provide platform for startups as an incubator. Then there are private accelerators, there are sector specific incubators also. So most of the research organizations, we have academic incubator which is provided by Venture Center NCL. Then we have by DRDO, that is also in the government PSU sector. Most of the corporates, they also provide incubator platforms. So basically these incubator centers, they provide all the required infrastructure and we can say guidance, because they have a lot of technical people on their panel, which provide mentorship to the startups and for their IP development also. So again, when we move to why IPR is important for in research, because there is always a value that you create out of your creativity. So that value should be protected. And as I already mentioned, that IP is there, but until and unless you protect it by that right, the IPR is not created. So, what does IPR provide? It gives you ownership recognition, it prevents unauthorized use and copying, it enables monetization, it strengthens your research profile, it supports collaboration with industry, startup, and investors, it helps attract funding and grants, it converts research into actual real world products, that is, market output, and it promotes the innovation culture. So, that is why it is always good that you safeguard your IP by converting it into IPR. Now, most importantly, there are some examples that I had taken from the point of view of civil engineering, but this can be applied at large. So this was a patent that is commercialized. It is a bacterial self-healing concrete technology. It is a concrete infused with calcite producing bacteria that seals cracks when exposed to moisture, and it increases the structural life, reduces the maintenance cost by 30 to 50%. So this particular invention, the inventor is Professor Henk Jonkers and his team, and it was later licensed to Basilis Concrete of Netherlands. So once it was commercialized, it is now deployed in tunnels, bridges, and marine structures. So this is an entire, we can say, a commercialization life cycle. So earlier there might be they might have looked for potential investors, or then they might have got some offers, and then it got commercialized by licensing. Now when we say it is licensed to some technology, this can be either a exclusive or non exclusive license. The another example is railway track crack detection system by IIT Bombay. So here it is sensor based ultrasound system that detects micro cracks in rail tracks in real time, and it is integrated by Indian Railways in live test routes to reduce the derailment risk. So this is again a patent that is the applicant is IIT Bombay. So this is again something which is developed from academic background, and it is adopted by Indian government, and it has a large scale impact. Then another is the GFRG, that is Rapid Housing System, developed by IIT Madras. So this they have glass fiber reinforced gypsum, which is also used in the Pradhan Mantri Awas Yojana and low cost housing. So it helps in 60% faster construction, 40% lower cost, and it is licensed to construction firms. So whoever will be the vendors of this PMAY, it is licensed to them. So it is again something developed from university, patented, and it has a national impact. Then we have a patent from CSI or NBRI, reinforcement for rural roads. So bamboo polymer composite bars to replace steel in low load rural infrastructure. So in northeast regions and Himalayan regions, for low cost bridges and rural roads, they have used it. So it is again use of an indigenous resource, which is something which is solving a local problem. So it is again a part of sustainable engineering. So these are some of the case studies where we can see that the entire patent life cycle and the technology transfer takes place for a successful application or successful revenue generation. So that's all. Uh, if we have any, yes, then there is also something. If we are looking into AI generated content, it is something that in the Indian scenario, at least it is not yet, we can say, refined yet. But definitely in India, inventor has to be an individual. Any kind of AI cannot be an inventor. Applicant is also has an entity type, which is individual, startup, small entity, large entity, or educational institute. So AI cannot be an entity type in when we apply for patent or trademark or any kind of IPR in India. So basically, in US and EU also there has been a case of DABUS. So the AI, there was a case of Thaler versus DABUS, and that particular patent was rejected when the applicant was this particular inventor and applicant was DABUS. So US, European Union, and Australia have rejected these patents. And similar for copyright, copyright has been denied uh, by for the AI generated work. So basically, in the Indian scenario, still it is in the developing stage, but we can say that AI can be used as an assistant for whatever research is there. It can be used as a tool, but it definitely cannot be said that can hold an ownership to an IP or an IP right. So we can use it to transform whatever research we do, but definitely it is not an owner. So yes, there will be a lot of input that we get from AI, but still it will not hold ownership. So that is IPR in AI generated content. Yeah, that's all. So
Thank you
if
so
we
much,
have
ma'am.
any questions, we can take
Yes,
that.
session is open for questions. All the participants, if there is any query or question, you can directly ask or write it in the chat box. There is a question, ma'am.
Yeah.
How a patent generates royalty for an inventor, especially relevant to civil engineering innovations?
Okay. So when I say that at the stage of licensing, when you license your patent, at that stage you can generate royalty. So suppose you file a patent application now and it gets granted in 2.5 years, but still from the date of filing itself, if you start working your invention, working in the sense whatever product or process is there, and if you start making use of that invention, if you start selling the product, or if you are using that process to sell a product, whatever revenue you generate, that you can generate on your own. Or if you license it, suppose you have an exclusive or non-exclusive license, then there is a percentage that you fix when you file this licensing deed, and that percent of royalty they give you. So suppose their company's turnover is so and so, so 5% of that will come to you. So that is what we call as licensing strategy, and that particular royalty will keep coming to you as long as that license is valid. Suppose you file license for 5 years, for 5 years that royalty you will get.
I hope the expert has answered the question. Mr. Ashutosh Kumar, are you okay with this? Yeah. Are there any other questions from the participants? I think there is some query from his side. Yes, sir, you can go ahead. Mr. Ashutosh Kumar, are there any further questions? Yes, are there any questions? Okay, then we will be concluding this session now. Thank you very much.
Yes, there is, I think, a question.
Okay.
Patent on design of a plate anchor. So yes, what you can do is you can when you need to work on your invention and you do not have the platform that is there, you can always access incubation centers. So whatever is your project details, you can send to this incubation centers so that you get some potential investors. There are always parties who are ready to fund your projects. So these potential investors or incubation centers will provide you the platform that is necessary, and then once it starts working, you will get the royalty. So you have to send the project details to potential incubator centers in India. And we have a lot of programs. We have BRAC program by the government of India. Then there are a lot of local incubators at every research center. So these incubator centers will definitely help you out.
I will request the participants not to leave the meeting. We will be having our valedictory session after this. Are there any more questions? Yes. Are there any more questions? There's one question, ma'am. I work on antenna design in my research work. Can I go for provisional patent?
Yes. So provisional you can definitely apply. That is, if it is not at a completely developed stage, you can file, and in 12 months you have to add all the details and file the complete. So if you feel that this is an innovative design, whatever research work you have done, you just quickly do a prior art search on your own on the open source platforms. And if you feel that it is novel, you can definitely file a provisional.
ಇಲ್ರಿ ಸರ್ ಹಂಗ್ ಬರಲ್ರಿ ಥ್ರೂ ಹೋದ್ರೇನೆ ಸರ್ ಬರುತ್ತೆ
I will request the
ಅವು ಅಷ್ಟೇ
participants
ತೋರ್ಸೋದು.
please shut their mics. Are there any more questions? Okay. So thank you very much, ma'am, for such an insightful and enriching session. Your clear
Thank
and
you.
structured explanation of intellectual property rights covering patents, copyrights, trademarks, and innovation protection provided our participant with much needed clarity on safeguarding research outcomes and creative work. The discussion on patent types, documentation, filing stages, and timeline was especially valuable and highly relevant for faculty members and researchers. As this marks the concluding technical session of our FDP, our session has perfectly completed the objectives of the program by emphasizing the importance of protecting intellectual contributions alongside generating quality research. On behalf of Department of Civil Engineering and TSSM Bhimarabai Sawant College of Engineering and Research, we sincerely thank you for sharing your expertise, practical insights, and valuable time with us. Thank you once again, ma'am.
Thank you. Thank you.
So
It
with
was
this
my pleasure.
session, we come to the conclusion of this academic session of our 1 week FDP. Now I'll request HOD Civil Engineering Department and convener of this faculty development program, Dr. R.S. Karde, to please take over the session to conclude, to summarize the all the sessions of this FDP. Sir, please.
Thank you, Dr. Khurram. Before beginning with the summary, let me request all the participants that after this session, after this summary, you can start your video on so that we can take a screenshot of that. Okay. So over this FTP on research, funding, proposal writing, and IPR, distinguished experts from academia, research institutes, and industry. We're graced to have this all the sessions, all the experts. We thank all the experts that they were readily available. They have shared their valuable time with us. And let me just give a few notes about what they have covered. Day one, the first session begin with Dr. Sanjay Poekar, who introduced us to the research fundamentals. Because nowadays you can see there are various issues related to how to approach with a particular problem, how to start identifying the problems. So the fundamentals, problem identification, literature review, because literature is a never ending process. It continues till you submit any proposal or any thesis. So how to approach towards the literature review, how to find out the gaps from this literature review. After that, that session 2 begin with Dr. Mansoor Ahmed, who provided valuable guidance on structuring and writing quality research papers. Because research paper gives us an identity about what work we have done. We can refer various papers, even our papers will be referred by various. So it gives us an identity. So how to write a good quality research paper. That is also equally important. Second day begin with Dr. Mayur Jain. He explained journal selection because many times uh, whatever journal we want to select, we never know the scope of the journal. So how to approach a particular journal, how to search a journal, how to check the indexing databases, publication avenues. That was rightly explained by Dr. Mayur Jain in the day 2 of session third, followed by Dr. Chintamani Pari, who elaborated on paper submission process, peer review, and responding effectively to the reviewers. Because once a paper is submitted, we get some comments, some suggestions, some corrections from the reviewers. So how to tackle these things, how we can respond it, because a correct response, a proper response will lead to a successful paper publication process also. So that was effectively covered by Dr. Chintamani Bari. Then day 3, it was focused on the research funding and how to write a proposal, how the proposal should be written, what the things which we should avoid while writing the proposal was rightly explained by Dr. Virendra Bhojwani. So he discussed various research grants, various funding agencies, number of funding agencies are available. Each funding agency has their own eligibility criteria. So we need to study those eligibility criteria and then approach the proper funding agencies. Followed by Dr. Guru Munawali. He explained about the what are the important things for preparing a strong and a competitive proposal, because a proposal is never a singing, there are never a single, there are hundreds of research proposals, so we have to compete with those at national and international level. So how to make a strong and competitive proposal, that is also a very equally important in current scenario. Fourth day, it was about ethical research, because ethics is also equally important in the research. What are the productivity tools? That was rightly explained to us by Dr. Mahesh Gadekar. And he highlighted about the plagiarism, ethical writing, because we cannot just directly copy paste the contents. We need to always give references, and we have to give original idea, whatever writing, whatever work we are doing, that should be original research work. So plagiarism, ethical writing, and how we can use the AI tools effectively was rightly pointed out. Also, Dr. Pichurajan Krishna Parmal demonstrated reference management and what are the support research support tools, so that we can enhance the research efficiency. And the last day, concluding day today, in the morning, Dr. Kishore Kulkarni, he provided insights into the research metrics, research profiles, and national and international collaborations. And now this current FDP concluded with Advocate Kanchan Rasa, who explained intellectual property rights, including patents, copyrights, trademarks, and innovation protection. So overall, uh, this FDP covered each and every minute aspect, whatever is necessary for funding, proposal writing, research paper writing, what are the things one can avoid, what are the precautionary things wherein we can avoid misuse of the articles, what best we can highlight, how we can compete with the world. All the things were rightly covered by these 10 experts. We also received good registrations, or more than 250 registrations from national and international peace speakers from the Taiwan and other countries. They have also appreciated participants from those countries, national, other states, other universities, Pune and other universities have participants from research students, PG students. They have also attended this conference. They have registered for this. So I truly say that yes, this program has successfully, I hope that it will strengthen whatever research competencies, and it will give or we can reaffirm our commitment to academic excellence and research advancements. So with this, we can hope that you just stay connected with us, even though we are at the end of this session, but still you stay connected with us and we'll continue our research journey. So I thank from the Department of Civil Engineering, Vivarabai Sawant College of Engineering and Research, Pune, and entire JSPM TSSM group of institutes. Thank you. Over to Dr. Khurram.
Thank you, sir, for summarizing the FDP. So we will have a short discussion. I want to have anyone from the participants who have any of their feedback, he or she can come forward. What we can improve on in future if we want to have these kind of FTPs and these type of conferences or events. What can we improve? Any suggestions, any feedback from any participant is welcome.
Bye.
I request all the participants to, for a moment, switch on their cameras so that we can capture this moment, this concluding moment of the FDP. Thank you, Dr. Prakash. You can also write your comments and your feedback in the chat box. Yes, on the behalf of TSSM's Vivarabai Sawant College of Engineering and Research and the Department of Civil Engineering, I extend my sincere gratitude to all the distinguished resource persons and to you, all the participants. We hope the knowledge gained during this FDP will contribute significantly to your research quality, academic growth, and professional development. Thank you all, and have a wonderful day ahead.
Thank you. Khurram sir, what about the certificates?
Yes, for the certificates, we will be sharing the certificate. We will check the actual participation because, as mentioned earlier, the participation is necessary for obtaining a certificate.
Okay, sir.
We will be sharing the feedback link of this session shortly on the WhatsApp group.
Love test with the boy. Allah.
Khurram sir, can we leave now then?